The government may not use coercive threats to suppress speech, but it is entitled to speak for itself by informing, persuading, or criticizing private speakers. Respondents don't have standing at all because they have not shown an imminent threat that the government will cause a platform to moderate their posts in particular. But the lower court still reviewed a vast range of speech by different officials to different platforms about different topics at different times without asking whether it had anything to do with respondents. And the courts then entered a universal injunction restricting speech about any content posted on any platform by anyone and binding thousands of officials, including presidential advisors speaking to the public and FBI agents trying to protect the nation from foreign threats. If this court reaches the merits, it should reaffirm that government speech crosses the line into coercion only if, viewed objectively, it conveys a threat of adverse government action. And because no threats happened here, the court should reverse. Similarly, I think both the Fifth Circuit and my friends have really said that the crux of what they claim was coercion here was what happened in July of 2021 when the Surgeon General, the White House press secretary, and the President himself made statements criticizing the platform's practices on misinformation and false statements about COVID vaccines and calling on them to do better. I think it's really troubling, the idea that those sorts of classic bully pulpit exhortations, public statements urging actors to behave in different ways might be deemed to violate the First Amendment. And I think if the injunction were to go into effect and the president or his senior advisors, the president isn't enjoined, but if his senior advisors, the press secretary or someone else, wanted to talk to the public about other problems like the circulation of anti-Semitic or Islamophobic content on the social media platforms, or the effects they might be having on children's mental health, or national security issues like the anti-Semitic Osama bin Laden letter that was trending on TikTok at the end of last year that we referenced towards the end of our brief. I think all of those things could be done only under the shadow of the injunction, and that comes around to the other point that you made, which is that this injunction, especially read in light of the opinion that comes before it, is extremely vague.
Behind closed doors, the government badgers the platforms 24/7. It abuses them with profanity. It warns that the highest levels of the White House are concerned. It ominously says that the White House is considering its options. And it accuses platforms both of playing total Calvin ball and of hiding the ball, all to get the platforms to censor more speech. Under this onslaught, the platforms routinely cave.
I mean, how do you analyze a situation where, maybe EPA is trying to coerce the platform about something and the Army Corps of Engineers is trying to coerce them the other way? I mean, you can't just sort of pick and choose which part of the government you're concerned about.
Your Honor,
and obviously it's a different when you're talking about what the president is saying in particular, but other than that, I think it's a very more a fluid situation than anything else.
It is fluid, Your Honor, but I would say that when you have, as we have plaintiffs in this case who wish to express certain viewpoints that have been specifically targeted by the government, it's not at least fluid in these facts. And this is not a case just about COVID. It's a case about election integrity. It's a case the district court has a finding about how the government.
So, I mean, what
wishes
about
to.
that? I mean, take an example where, I mean, these platforms, they're compilers of speech, and some part of the government, let's call it part of the law enforcement arm of the government, says you might not realize it, but you are hosting a lot of terrorist speech, which is going to increase the chances that there's going to be some terrible harm that's going to take place. And we want to give you this information. We want to try to persuade you to take it down. The government can't do that?
The government can absolutely do that, Justice Kagan.
They're asking them to take down the speech.
Terrorist activity, criminal activity that is not protected speech, absolutely, the government can inform
much of it might be protected speech. I mean, terrorists engage in, things that come under the First Amendment. I mean, let's say they're just recruiting people for their organizations.